Hello everyone, welcome to Lex Gyan's lecture series on Indian Evidence Act. Today we shall be studying about presumption under Section 4 of the Indian Evidence Act. So what exactly is presumption? Presumption is when there is no direct evidence that is offered or obtainable. Disputed facts are sometimes inferred from other facts which are themselves either proved or known. In such a case, the inference drawn from such proved or known facts is called as a presumption. For example, if you haven't heard of a man for more than 7 years, the man shall be presumed to be dead. The concept of presumption is to seal the gap which may exist. It is pertinent to note that presumption has no role when actual facts exist. So let us understand the bifurcation of presumption under the Indian Evidence Act. Presumption is divided into presumption of fact and presumption of law. Presumption of law is further divided into rebuttable and irrebuttable. Presumption of fact would be may presume, rebuttable presumption of law would be shall presume, and irrebuttable presumption of law would be a conclusive proof. So before we go any further, let us understand what is the difference between presumption of fact and presumption of law. Presumption of fact is based on logic, human experience, and law of nature, whereas presumption of law is based on the provision of law. It is nothing but a statutory presumption. A presumption of fact is rebuttable in nature, whereas presumption of law may either be rebuttable or irrebuttable. Presumption of fact is at the discretion of the court, whereas presumption of law, the court does not have discretion over here and the court is bound to presume. Presumption of fact depends upon the facts of the case, therefore it is uncertain and transitory. But since presumption of law is a statutory presumption, it is certain and uniform and it does not depend upon the facts of the case and is not transitory in nature. So let us understand the meaning of may presume. May presume suggests that the fact may be assumed. It is at the discretion of the court. Therefore, the court may or may not presume such a fact. In the case of Hamid Johran versus Abdul Salam, the Honorable Court held that the word may is a common acceptation, means and implies a possibility, depicting thereby availability of some fluidity and thus not conclusive in nature, which basically in simple words means that the word may signifies discretion. A few examples wherein the term may presume is used in the Indian Evidence Act are Section 86, 87, 88, 90, 114 and so on and so forth. In the case of Jagdish Narayan versus Krishna, the wife of the deceased husband turned hostile in the court and stated that she left her in-laws' house with her 5 minor children willingly and denied being threatened or forced. The Honorable Court presumed that she must have been threatened or forced, as it is unthinkable in a Hindu family that a daughter-in-law would desert her in-laws' house with 5 minor children after the death of her husband. This clearly shows that the word may grants discretion to the court to presume facts based on the matter of the case. Let us now understand rebuttable presumption. Rebuttable presumption is a presumption of law wherein whenever it is directed by the Indian Evidence Act that the court shall presume a fact, the court shall regard such fact as proof unless and until it is disproved. Herein the court has no discretion whatsoever and it shall be bound to presume. In such case, the burden of the proof lies on the opposite party. In the Mathura rape case, that was the landmark case that led to the introduction of Section 114A, which shifts the onus on the accused to prove that an act of rape was not committed. The burden of the proof before was upon the victim. However, in the current scenario, if the victim states that there was no consent, a statutory presumption shall be raised in favor of the victim. Thereby, it is on the accused to prove that the rape was not committed. The third shall herein binds the court to do so, and the court has no discretion in such matters, and it must take the presumption as directed by the Indian Evidence Act. Let us now understand irrebuttable presumption. Irrebuttable presumptions are conclusive, permanent, or irrebuttable in nature and cannot be overcome by any evidence. The fact is declared to be a conclusive proof. Let us take the example of when a child under the age of 7 years cannot commit an offense. It is an irrebuttable presumption. It is an irrebuttable presumption as even if a person gets a proof to show that the child did actually commit the offense, the court would disregard such an evidence. In the case of Kamti Devi versus Poshiram, the Honorable Court disregarded the evidence produced by the husband stating that he did not have access to the wife, stating that a rebuttable presumption of legitimacy is attached to a child born of married woman during subsistence of marriage or within 280 days of its severance. Therefore, any evidence that would prove the otherwise would be not considered by the court, and the conclusive fact would remain that the child is a legitimate child born out of the wedlock. Thank you for watching. Please like, share, and subscribe for more such videos. You can write to us in the email ID given in the description for any queries. You can also follow us on Instagram, Facebook, and LinkedIn for more valuable legal insights.